All right, we're back on the record. Show the presence of counsel and the defendant. The jury is absent. Before we bring the jury in and continue with the cross-examination of the witness, a couple of things I just wanted to hear from the parties about. First, when we discussed the additional possible witnesses for the defense, I might have missed it, but I don't recall Detective Barba's name. But the courts limited additional cross-examination by the defense to Detective Barba. But I did rule and intend to obviously honor the ruling that you could recall Detective Barba in the defense case and examine him and use leading questions, whatever, with respect to whatever remained. So I just wanted to make sure that that was still understood to be the ruling of the court, and that's still there.
Yes, we understand that, Your Honor.
All right, and you're not intending to call Detective Barba?
We haven't decided yet. He's out there. If we get what we need from the other witnesses, then we won't.
Okay, very well. So that should resolve that issue. Now, also, the court recalls that with respect to the current witness, Sheriff Hathaway, there was a motion in limine that was filed, I think, on behalf of the state with respect to that witness. And I don't think we got to that as part of pretrial rulings, but I just wanted to anticipate an issue. Maybe there is no issue. What's the state's recollection? Then I'll hear from the defense.
Your Honor, I think the defense has already started to cross-examine or to question him with respect to whether he was legally authorized to do what he did in Mexico. I mean, clearly he was. Clearly he had legal justification. I don't think that's relevant to this case anyway, because if he did something wrong, that would be a separate issue anyway. It has no bearing on the interview with Daniel here. So I would ask that we not go any further into that at this point, or that the court instruct the jury that it's not relevant.
All right, well, what my intention was, I'll hear from the defense, my intention was, questions have been asked, I didn't hear any objection, but just to deal with it on a question-by-question basis and see where you go.
Yeah, my recollection was we discussed that motion, and that's essentially what your ruling was that I was allowed to ask the sheriff questions, and we would see what came up at trial.
All right, fair enough. I just want to get that out on the table so we didn't let something like that fall through the cracks. All right, if there's nothing else, then we can bring in the jury. Thanks.
Please rise.
Thank you. Everyone, please be seated. The record will show the presence of all the jurors, counsel, and the defendant, and we can have the witness retake the witness stand, please.
I went to go grab him.
Morning, sir. Retake the witness stand. Thank you.
Good morning. What was that? I don't know.
All right, the witness is back on the stand. I always inform every witness who's had a break over the evening that you're still under oath.
Okay.
Very well. And you can continue with your cross-examination, Ms. Larkin.
So I want to talk some about this interview that you did with Daniel in Mexico. Prior to meeting with him, can you summarize the background information that you had about this case?
There's probably a lot of things more than I can summarize, but that there was a killing on January 30th of 2023 in the Keno Springs area on a property that pertained to an individual named George Kelly, and that evidence had been collected at the scene. Shell casings and a body had been recovered at the scene. I was informed about various 911 phone calls, various other communications with Border Patrol, with Ranch Liaison Officer. I could be missing some things, but that's it in a nutshell.
Did you know where the body was located in relationship to the house?
No, I do not.
Did you know where the house was located in relationship to the border wall?
No, ma'am, I do not.
Did you know about other witness statements before you met with Daniel?
I had heard some things. The summary of the 911 calls.
Had you reviewed a statement provided by a person calling himself Miguel?
I don't recall that.
Had you reviewed a statement provided by a person named Ramon?
No, I had heard about Ramon, but I didn't review a statement.
So you weren't aware of what either of those people had said?
That's correct.
And we talked yesterday about some of the ways that you test the credibility of a witness, right? And what you said one of those ways was comparing a witness statement to other witness statements, right? And another way was comparing a witness statement to the physical evidence, right?
That's correct.
Without knowing the content of those statements and without knowing the facts on the ground in this case, how were you planning to test Daniel's credibility?
I know probably as one individual more than anyone else in the sheriff's office about the overall aspects of this case, since I am the sheriff and I was briefed continually on it. I did not go to the crime scene, but I can test, for example, that Daniel said that an AK-47 was fired, that he recognized the sound, and I know that an AK-47 was recovered and shell casings from an AK-47, so that's one example of testing the, what he said. Another example was a horse, a reddish-colored horse that he said saved his life, that was running next to him when the shooter was on the opposite side of the horse shooting at him, so there was a horse.
So I don't want to get into what he said to you specifically, but I just want to understand what you had available with you to test his statement. You know some facts about the case, but you don't know where the property is, you don't know where the body was located, right?
I know where the property is. I didn't go there, but I know generally where it is.
You don't know where it is in relation to the border wall?
Generally.
Okay. You don't know what position the body was found in when he died, right?
That's correct.
You know that a horse was not shot during this incident, right?
That's what I was told, that a horse was not found shot.
Okay. Another way to test a witness's credibility is to provide photo lineups, for example, right?
That would be correct, yes.
And to see if they can make an identification, right?
Yes.
So one way that Daniel's credibility could have been tested would be to provide a photo lineup, including Mr. Kelly's photo and other photos of other people who look like him, right?
Well, on the date that Daniel showed up, which we didn't know if anyone was going to show up or the name of the individual, we didn't know the nature of the beast. We didn't know what we had on our hands. So we were doing this in Mexico. We didn't have every investigative avenue available to us, nor did we know what would come up in his statement that we would need to compare with.
So you weren't prepared to even try to get him to identify somebody?
We were prepared. We did ask about the individual that was doing the shooting.
Did you bring any photographs?
We need to let the witness answer the questions, please.
Can you repeat the question? I can't remember what it was.
Did you bring any photographs with you to try to let this witness make an identification
No,
on
not that I
photographs?
recall.
You had photographs of this other witness, Ramon, correct?
I don't know. One of the detectives may have had photographs of him.
Did you bring any photographs of Ramon to try to do a lineup of Ramon with this witness, Daniel?
No, I did not.
That would be one way to test his credibility, right?
That would be discussing one aspect of a thing that didn't directly involve the shooting. Was Ramon was not alleged to be at the shooting, only two individuals, Gabrielle and Daniel.
You didn't believe Ramon was alleged to be at the shooting?
Not from what Daniel said. He said there were two individuals, the group scattered at Duquesne Road. Two ran back to the border, which was Gabrielle and Danielle.
So, and you hadn't reviewed Ramon's statement, I understand that. Detective Barba had interviewed Ramon, right?
I think that's correct, but I don't remember for sure.
Were you aware that Ramon was also claiming he was at the scene of the shooting? He was there.
I was aware that he was alleged to be part of the initial group of 7 migrants that came in going towards Duquesne Road, which was referred as the road to Washington Camp or Mount Washington. And then when they saw a Border Patrol vehicle, they scattered, and only the 2 individuals were on the area where the shooting happened on the return. That's what I'm aware of.
And you're aware of that because Daniel told you that. Is that where that came from?
Well, that would be one way that I was aware of that.
What was the other way you were aware of that?
I don't know.
That's just
Yeah,
what
that was-
Daniel told you, probably.
That's what
right?
Daniel told us.
Okay. So if I told you that Ramon said he was there and he saw this shooting and he was with a whole group and the whole group was present when this shooting happened, that was his statement. That would be something that you would try to compare to Daniel's statement to test his credibility, right?
I'm not aware of what Ramon said.
If you're going to test a witness's credibility by comparing his statement to somebody else's statement, you should probably be aware of the other person's statement. Shouldn't you?
If a person had the mechanism to do that, I didn't know what I was going to encounter in Mexico on February 15th. An individual did show up. I didn't know who they were going to be or what they were going to say. So I documented what they said.
And you didn't do anything to test his statement against other statements that had been put forward in this case, did you?
I know the detectives were working on this case, and I'm aware that they did that type of thing, pursuing many different avenues beyond what I pursued. So they were doing those kind of things, comparisons.
Which detective did that?
I don't know.
Did you ever review a report from any detective that compared these witness statements to each other?
I don't recall reviewing a report that did that particular thing.
Is it possible that nobody did that?
I don't know. I didn't review all the reports in the case.
During this interview with Daniel, we know this other witness, Ramon. He was out there before. Do you recall Detective Barba providing his name to Daniel?
I do recall Detective Barba providing his name to Daniel, yes.
And a better way to test Daniel's credibility would be to ask Daniel who else was with you. Wouldn't that be a better way to do that?
I do know that he did describe there was a group of 7. They were scared when they got to Duquesne Road and saw a Border Patrol vehicle, and then 2 of them ran back. So I know he did a description of who was there. It was a group of 7 originally, and then it was weaned down to a group of 2 after everybody scattered.
So that wasn't my question. My question was to test Daniel's credibility. If you have another witness who says he was there, rather than providing that witness's name to Daniel and saying, do you know this guy? A better way to test his credibility would be to ask Daniel, did you know anybody else in the group? And if so, what were their names? Would that be a better way to approach this interview?
I don't know, that's, Detective Barba was aware of the name Ramon, so he did ask about that name, and I don't know if there was better ways to do that.
It's pretty suggestive to just provide another person's name to a witness in an interview, right?
Well, that was a piece of the case that Detective Barba was aware of, and so he asked that question, and I don't know if there would have been a better way to do that.
My question was, is that suggestive?
He's already answered that question. He said he doesn't know. So that's the answer.
Okay.
Let's move on.
Did you later, so after you did this interview with Daniel, did you record a portion of this interview?
Yes, I did.
Tell me about that. What did you not record? What did you record, and why?
I would say the whole encounter was possibly, this is an estimate, 45 minutes to an hour. I think that video recording was 6 minutes and 40 seconds. So it was a summary, just a thought I had at the end of the interview. If something happened to this witness, if he disappeared, if he wound up getting killed, I wanted to have something other than my word and Detective Barba's word that we had actually talked to the witness. So it was a summary of the events of that day, and I'm sure there were things covered in the overall interview that wasn't recorded that are not captured in that video interview.
So you spoke with him for a while and then recorded this 6-minute portion after you had substantially finished the interview.
That's correct. Before departing, just wanted to create evidence that this encounter had happened.
Why didn't you record the whole thing?
Didn't think of it until we were at the end.
You didn't think of recording a witness interview?
I didn't think of that. I think most witness interviews on the street are not recorded or not video recorded, but I did just think the nature of this individual, he didn't have legal documents to come into the U.S., just thought, is there a possibility I'll never see this witness again? Maybe it would be good to do a summary, a little video summary, to show that we had actually met with an individual.
It's standard practice to record witness interviews,
And
right?
Not necessarily in my career. Most witness interviews are not recorded.
When you pre-arrange a witness interview and you have time to plan to do the interview, is it best practice to plan to record that interview?
This was an ad hoc situation where somebody may show up. Juan Carlos Rodriguez said he would try to arrange an encounter with this individual. I grabbed a detective. I went to the location to see if anybody would show up. And we weren't at our office. We didn't have the full range of equipment that we would have at the office. We didn't have like a forensic team with us. It was just me and Detective Barba. And we just did the best we could in Mexico, just doing an interview with this witness that did show up.
You had your phone with you,
That's correct.
and you used it to record a portion of the interview.
That's correct.
Why didn't you just use it to record the whole thing?
I didn't think about it.
Who is Big Super?
He has a YouTube channel.
Is this a person that you talked to about this case?
I talked to
Objection,
him.
Your Honor. Relevance?
All right. This is something new, so let's have a bench conference. All right. The court's ruled at the sidebar, and you may proceed with your direct examination. Excuse me.
Did you make comments to Big Super about Mr. Kelly's case?
As the public information officer for the sheriff's office, I try to be transparent and talk to anybody. This Big Super individual wanted to do a border tour, and while we were doing that border tour, he asked me, what about vigilantes? Do you have vigilantes on the border? And I gave an answer which I didn't say Mr. Kelly's name. I said, we have a situation where there's a rancher that shot at 2 migrants and killed one of them, and the other one got away. I did mention that incident, and I didn't say the name George Kelly in that interview.
Did you say that he just wanted to go hunt him some Mexicans?
No. After that comment, I did segue into a collective pronoun, the word they, that there is a type, that they want to go hunt themselves some Mexicans. They want to have the mystique of the Old West, of the border, get some excitement, and we've had individuals that do that. Like, well, there was one called Take the Border Back, a group that just came in not too long ago, a bunch of armed individuals. I told Big Super that this was rare. It was not common, but it does happen occasionally.
You told Big Super, we caught this rancher shooting at migrants. And then you said that there are people who want to come hunt some Mexicans. You made that statement.
Yeah, I just did a kind of colloquial. There are some people that they want to go hunt them some Mexicans. Yeah, I did say that statement.
Right after referencing Mr. Kelly's case.
And I didn't mention Mr. Kelly, but I did generically refer to a type that has that attitude.
You didn't say Mr. Kelly's name, but that's who you meant, right?
That is who I meant.
Thank you. You also tell him something about pet ranchers. What did you say about pet ranchers?
Something to the effect that there are ranchers that are on speed dial for certain news outlets, that they will interpret everything as a crisis, as that foreigners are hostile, foreigners are here to do us harm. So I did reference that there are people that can get on the news by talking this sort of crisis mentality, hostile nature of foreigners, rather than them just coming here to work, but that they're here to cause harm.
And your implication was that that's totally exaggerated?
That's exaggerated?
What the ranchers
Yeah.
are saying, exaggerated, right?
Yeah, that's
Okay.
my implication, yes.
You talked yesterday about how you don't really get involved in a lot of cases, even the major ones. I just want to ask you, why did you involve yourself in this case?
It was mainly because of the specific nature of the Mexico interview, and I had done so many interviews like that when I worked with the DEA. And I've been going to Mexico my whole life. I was born in Nogales, Arizona, grew up here in Nogales, Arizona. I've been going to Mexico my whole life, in addition to my DEA career, which was largely in Latin America. So it was easy for me to go and talk to an individual in Mexico, whereas for others they may be reluctant to do so. So it just seemed like a natural, easy thing for me to do.
That's the only reason?
Yes.
I don't have anything else, Your Honor.
Cross-examination from the state.
Yes, Your Honor, real briefly. Sheriff, let me ask you the question about the report and the video, or the video recording and the report,
Yes.
right? You recorded via a report, right, the interview?
There was an interview that happened, and then at the end of that interview, I synopsized the interview in a video recording.
And there's a report on this, right?
There's a report about the entire interview. That's correct.
And Detective Barba was with you, correct?
That's correct.
And Detective Barba is one of the detectives on this case, right?
That's correct.
So if you had any questions or concerns, Detective Barba is there to assist you.
That's correct.
And you talked about, are you familiar with where the victim's body was found in relationship to the Kelly home?
I'm not aware of the specifics.
Are you familiar with, comfortable with 115 yards?
I'm not aware of the specifics. It's only as what I've been briefed. I've been briefed to that number, but it's just based on a briefing.
Well, let's just I'm going to give you a hypothetical. If someone's standing 115 yards away and there's brush, is it easy to make an identification on somebody? If you're 115 yards away, there's brush.
It depends on the nature of the terrain. Like I have a ranch in that same area, and I know what the terrain is like, and it depends. There could be mesquite trees or things between the individuals, or it could be open space. It's hard to say without actually looking at the crime scene.
And also, too, have you ever been shot at with an AK-47?
No,
Do you have a lot of officers under your employ that has been shot at by an AK-47?
no.
Also, too, the questions about credibility with Daniel when you're in Mexico, one of the things you talked about was you knew something about the case, so you're asking Daniel to tell me your story, right?
That's correct.
And you're checking that mentally with the facts that you know that Detective Barba or Detective Ienza told you about the case, right?
That's correct.
And you gave a couple examples, right?
Yes.
One example was a horse.
Mm-hmm.
Is that yes?
Yes.
One example was AK-47 being shot.
Correct.
So in your opinion, did Daniel seem credible to you as you interviewed him on February 15th?
Objection, foundation, and argumentative.
Sustained.
No more questions, Your Honor.
Redirect.
I don't have any redirect.
Thank you. All right, ladies and gentlemen of the jury, any questions from the jurors for this witness? Appears we have more than one, so we'll go to the bench conference. I have questions from 3 different jurors. I'm going to mark this Hathaway number 1. Sheriff Hathaway, do you and Mr. Kelly know each other? And if so, please describe your rapport. Same juror, did you involve yourself with this case for political gains? All right, that's Hathaway number 1. Let's see, there's Hathaway number 2. Two questions. In your testimony, you stated that the county attorney's office and your deputy sheriffs were nervous about going to Mexico to interview a potential witness. I'm still not clear on why they would be nervous, unless it was not a legally authorized method to interview a witness in another country. Can you please explain again? Second question from the same, same juror. Based on what you know today and based upon your evidence with Daniel, do you believe he is a credible witness? All right, I just sustained an objection to that question. Okay, so I'm not going to ask that question. I already sustained an objection to that question. Okay, this will be Hathaway number 3 from a 3rd juror. Can you state if Daniel Ramirez was left or right-handed? If he knows. Second question, same juror. During interview with Daniel, was he wearing any what seems like new clothes, shoes, jewelry, or electronics? All right, that's it. Question from some of the jurors. Sheriff Hathaway, do you and Mr. Kelly know each other? And if so, please describe your rapport, or I would assume your relationship.
My family has a large ranch in the same area, Duquesne Road, Keno Springs area, as Mr. Kelly's property. So it's possible that I've met him, but I don't recall specifically having met him in the area while working on the Hathaway Ranch.
Second question, did you involve yourself with this case for political gains?
No.
Additional questions from an additional juror. In your testimony, you stated that the county attorney's office and your deputy sheriffs were nervous about going to Mexico to interview a potential witness. I'm still not clear on why they would be nervous unless it was not a legally authorized method to interview a witness in another country. Can you please explain again?
Just speculating, maybe they hear about the danger in Mexico, that it's dangerous down there, and they don't want to expose themselves to that kind of danger, but I don't know exactly why.
And questions from another witness. There was another question from that juror, but I had already ruled on that question before, so I won't ask that one. But another question, two questions from another juror. Can you state if Daniel Ramirez was left or right-handed, if you know?
I don't know.
Another question from the same juror. During the interview with Daniel, was he wearing any what seems to be like new clothes, shoes, jewelry, or electronics?
No, not that I recall. He was dressed humbly.
All right, those are all the questions from the three. Any other questions from the jurors? All right, we have another question from a different juror. Let's get that. We'll go on the sidebar for that. All right, we are back on the record. I made some rulings that, to the effect that part or some of these questions will not be asked because they may have been asked and answered, or for other reasons. But witness having answered questions that I've allowed from the jurors, is there any follow-up questioning to the questions of the jurors from the defense,
No, Your Honor.
from the state?
Yes, real briefly, Your Honor. Let me talk about, there's a question about the attire of Daniel. Your answer was humbly.
Correct?
Does Daniel appear to be a man of means?
No, definitely not.
Let me ask you, too, about the type of cases that the Sheriff's Department and the County Attorney's Office prosecutes here at the border. Would that be a reason why officers and attorneys would be nervous about going to Mexico?
Objection leading, and it exceeds the scope.
I'm on cross, Your Honor.
Well,
Exceeds the scope.
It's a direct question about the nervousness of people from the Sheriff's Department or the County Attorney's Office going southbound.
yeah, I think I'll allow it. Frankly, I think it's been asked and answered, but I think he's already answered it. But if there's something new to his answer, we'll hear it.
Let me repeat the question.
Yes, could you repeat it?
Sure. Would the type of cases that the Sheriff's Department and the County Attorney's Office both investigate and prosecute be a reason why agents and attorneys are nervous about going to Mexico?
Possibly, but I don't know.
Thank you.
Any other questions from this witness, from any of the jurors? Thank you, sir. You could step down.
Thank you.
The defense can call its next witness.
Call Detective Raul Rodriguez.
Do you solemnly swear that the testimony you're about to give in the matter before the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Thank you, sir. If you come over to the witness stand, please, and have a seat. Whenever you're ready, Ms. Arthur.
All righty. Can you hear me okay?
Yes, ma'am.
Okay. Could you tell us your name and spell your last name for the record, please?
Raul, R-A-U-L, Rodriguez, R-O-D-R-I-G-U-E-Z.
And you are currently retired, is that right?
Yes.
What was your employment prior to retirement?
Prior to my retirement, I was a lead investigator for the Santa Cruz County Attorney's Office.
Did you become involved in the case involving George Allen Kelly at some point?
Yes.
Could you just describe your initial involvement in that case?
My initial involvement is just to go over the reports, information that the Sheriff's Office investigators had done on that case, and on with the witnesses.
And this is regarding an incident that took place on January 30th of 2023, right? That's the date of the incident, right?
I believe so, ma'am.
You weren't involved on January 30th, 2023, right?
No, ma'am.
So what did you review initially in this case?
Just initial reports as to the investigations that was being conducted by the Sheriff's Office criminal investigation.
Were you ultimately tasked with conducting an interview or assisting in an interview of a person named Daniel?
Yes.
Did that interview take place on or about February 23rd of 2023?
Yes.
Where did that interview take place?
At the Cassini Port of Entry.
Describe to me how that got arranged.
That was arranged by various telephone contacts with the victim to arrive at the Dean Casino Port of Entry, and with some logistics and phone calls with U.S. CBP personnel at the port.
And is it your understanding that the county attorney's office was able to communicate with the port authorities to allow Daniel to come there to meet with you folks?
That's correct.
Okay. So that meeting didn't take place in Mexico, right?
No.
Okay. Tell me what you had reviewed or what your background information on the case was prior to interviewing Daniel on February 23rd.
Background information was that the Santa Cruz County Sheriff's Office was conducting a criminal investigation into a homicide that occurred in Aquino Springs. Prior to that interview, Daniel was identified as a victim witness in that case, and arrangements were made to speak to Daniel at the port.
Were you aware before interviewing Daniel that any other people had come forward as witnesses in this case?
Yes.
How many other people?
I believe 2 other gentlemen were identified by the Santa Cruz County detective.
Okay. So in your review, you were aware of a person named Miguel who came forward, right?
Not too much. I didn't know a lot about his background, but I know the first name was Miguel.
Okay. And had you been able to review his statement prior to interviewing Daniel?
No, I did not.
Okay. And so you didn't know what he said prior to
No, I
interviewing
didn't.
Daniel? What about a person named Ramon? Were you aware that a person named Ramon had come forward as well?
Yes.
And same question, had you been able to review Ramon's statement prior to interviewing Daniel?
No.
Okay, so you don't know the content of those statements,
No.
right? Okay. Before interviewing Daniel, did you have any information involving the area where this incident was alleged to have taken place?
Yes.
What information did you have about the area?
That occurred in the vicinity of Aquino Springs at a ranch.
At a ranch. Were you familiar with the ranch at all?
Yes.
How so?
Prior to my employment with
I
the
don't understand.
I'm trying to turn it off, Judge. I don't know why it's doing this. I'll be right back.
There was a pinging noise.
I don't understand either.
Yeah. We're not going
Okay.
to go there. I can't even make a phone call on that. All right. Sorry about that. Go ahead.
That's okay. Tell me how you were familiar with the ranch property.
prior to my employment with the Santa Cruz County Attorney's Office, I was a lieutenant with the Santa Cruz County Sheriff's Office, and that was my area of responsibility jurisdiction through my career was the Sheriff's Office.
Keno Springs area
Yes,
in general, and out Duquesne Road, that area?
yes.
Okay. Did you know where Mr. Kelly's property was specifically, or did you just generally know the area?
Both,
Both, okay. Had you ever been to Mr. Kelly's property?
yes.
When had you gone to Mr. Kelly's property?
That was numerous occasions over my career with the Sheriff's Office, and maybe a drive-through at the inception of my career with the County Attorney's Office.
Okay. Had you seen Mr. Kelly's house?
Yes,
And so you knew where it was and you're familiar with what it looks like?
yes.
Okay. Were you provided any information in your review of these reports about where the body was located in relationship to the house?
No,
Okay, so that was not part of the background information that you had?
no,
Were you provided with any information regarding how the body was positioned when the body was discovered?
If I was brief on that, I don't recall that briefing.
Okay. Were you aware of where this property and where the house specifically is in location or in relationship to the border wall?
Yes,
And where is it in relationship to the border wall?
I couldn't tell you exactly. It's only approximately from the border.
Approximately how far
I would
away is
say,
it?
less than a mile.
Less than a mile, approximately?
Yes,
And this is also obviously on the east side of Nogales, right?
that's correct.
Okay. So that's the information that you had when you go into this interview with Daniel, right?
That's correct.
And when you interviewed Daniel, do you recall doing that interview?
I do.
And I'm just going to ask you about some of the statements that you made to Daniel in that interview, okay? Were you able to review a copy of the transcript of that interview prior to your testimony?
No.
If you need to refresh your recollection and you need to look at a transcript, just let me know, okay? And
I
I
will.
can put it up in front of you, all right?
I will.
Do you recall Daniel telling you in this interview that this took place west of Nogales?
Objection, Your Honor. Improper impeachment. I have the transcript.
And it's not for impeachment purposes, Your Honor. It's to show how this detective responded, given his knowledge of the case, to that statement.
And what was that, the exact question again was, did you,
Did he recall Daniel telling him in the interview that this took place west of Nogales?
all right, overruled, you can answer.
And Your Honor, if I may, we could talk on the headset about this.
All right. Objections overruled. You can ask the question again so it's fresh in the witness's mind.
So during this interview on February 23rd, do you recall asking Daniel where this took place? And do you recall him stating west of Nogales?
I have to see the transcript.
All right. Can you put this in front of the witness? Let me see if I can jump to the right page. Okay, so I'm on page 18.
Okay, let me have.
There's the bottom. So if it goes bottom of 18 over to the top of 19.
And again, ladies and gentlemen of the jury, this is being used to refresh the witness's recollection. It's not admitted into evidence, so that's why it's not on your screen.
Can you repeat the question, please?
Let me find it real quick. I think I'm on the wrong page. I am on the wrong page. There we go. Okay. So the question is, you asked the witness, where did this take place? And he said west. Is that right? I'm looking at line 5, 6 right there.
Yes.
Okay, so he told you this took place west of Nogales. And can you take a look at line 7 for me? 7, 8.
Yes.
And that's you translating the witness's statement, is that right?
Yes.
And you translated that as east, is that right?
Yes.
Even though you confirmed in Spanish, oeste, so you repeated that to him in Spanish,
Yes.
but then you translated that as east.
Yes.
Why did you do
Let's
that?
stop you. I just want to get an official, I think everyone probably, most everyone knows what that means, but, so the word in the transcript that the witness said was oeste, correct?
Yes.
All right. Can we ask the court interpreter to translate oeste? Translate the word oeste.
West,
All right. What's the word for east?
este.
All right, thank you. Apologies, you can go ahead. Excuse me.
So you incorrectly stated what this witness had said. Why did you do that?
I couldn't give you explanation of that.
You don't know?
No.
Is it possible that it had to do with the fact that you were familiar with this area and you knew that the area in question was to the east of Nogales?
Possibly.
And then you ask the witness another question. I'm going to jump to page 41. Give me one moment. Let's find the line. Oh, this is off. Give me one moment, Judge. I think it's taken me to the wrong page. Okay, so I'm looking at page 40. You were asking the witness some questions about distance, and do you agree that you're telling the witness the distance, I'm looking at line 14 to line 15, that's something that you're telling the witness, right?
I'm just affirming his recollection.
Well, you're saying, could it be the distance? Could it be more? Because 7 meters.
Objection, Your Honor. Improper impeachment, again.
I'm asking about this witness's statements, not about Daniel's statements.
Right, well, objection's overruled, but ask the question first, what did the witness tell you, or did the witness tell you this, this, and this, and what did you tell him? Just ask for his recollection first, and then if necessary, you can try to refresh his recollection with the transcript.
Do you recall telling Daniel at some point in the interview that he could possibly be wrong about distance because the distance he was giving you was not very much?
I wasn't telling, I was asking, could it be the distance? Could it be more? It was a
Why were you
question.
asking him that?
Open-ended question as to his recollection.
Well, he had previously given you a statement about a distance, right? Do you want me to scroll up so you can see that?
Yes.
So do you see around line 10 to 13, just if you could read that for yourself so you can refresh your recollection about the conversation?
Yes.
So the conversation in general, and I don't want to get into what the witness actually told you, but you're in general talking about a distance in this case, right?
That's correct.
And you're talking about a distance from the border wall, right?
That's correct.
He gave you a distance, right?
That's correct.
And then later you tell him, are you sure it was that close? Could it have been more? Something like that, right?
That's correct.
Why did you do that?
Because sometimes victims' recollections are different days, weeks afterwards, just to affirm his statement as to distance.
Well, when you say, are you sure it was that close? Do you believe that's suggestive to the witness?
I believe it's I was trying to elicit his detailed response to my question.
Well, he had previously given you a detailed response about a distance from where he was to the border wall, right?
That's correct.
But you didn't accept that. You asked him, are you sure it was that close?
It's a term of interview with the victims to reaffirm their statements.
Don't you believe that that's a little bit suggestive when you say, are you sure it was that close?
Well, the question is subjective as to the response, and so I would say it's just my interview with the victim.
Well, let me ask you this. He gives you this distance away from the border wall that this happened. When you heard that, based on your knowledge of the area, and you know the ranch, you know where it is in relationship to the border wall, based on his statement, did you believe that that statement made sense with the knowledge that you had of the area?
To the victim, it made sense.
But to you, did it make sense?
No.
Okay, because you know the area, right?
Yes.
And the distance he was giving you was way too close to the border wall to make sense.
That's correct.
And so you said, are you sure you were that close? Or words to that effect, right?
That's correct.
Okay. My pages are off, so give me a moment. I hope I can find this one. Do you at some point, you talked to him about a distance that a person, specifically the shooter was, when the shooter was shooting at him, right? Do you recall having a conversation with him about that?
Yes, ma'am.
And he gave you another distance in that instance, right?
I believe so.
Then, do you recall asking him or doing something similar with that distance, saying, are you sure you were that close? That's really close. Do you recall a conversation to that effect?
That's correct.
And was that sort of the same scenario? He's giving you a distance that doesn't make sense based on what you understand, and so you're asking him if he's really sure about that.
That's correct.
Fair enough? Okay. Do you remember at some point during this interview taking him outside to measure some distances?
That's correct.
Why did you do that?
Just to have the knowledge of his perception of distance.
And how was his perception of distance?
I believe it wasn't accurate.
It was or was not accurate?
It was not accurate.
Okay. And why did you believe that?
He was just nervous. I don't know. I think it was just his demeanor as to his exposure to the interview itself.
I'm asking you, what about his perception of distance do you believe was not accurate? Let me back up a little bit. You take him outside to actually measure something.
Just
Do you
not
recall
measure
that?
it. I just asked him, what do you believe this distance is?
And did you measure that to see if he was accurate?
It was approximate. I didn't measure it.
What was the distance that you asked him to estimate for you?
I couldn't recall without.
Okay. Do you know how far off he was?
He was not accurate.
How so?
Just by his response to my questions as to what's 15 meters.
Well, that was a distance you asked him about where he was in relation to the border wall when the shooting happened, right?
No, that was 15 meters that you have right here. Before me.
Okay, so I just want to talk about when you take him outside to determine if he's accurate with distance. How did you do that?
I'd ask him how much is 10 meters.
And what did he do?
He pointed out to a wall, and he said that was about 8 meters.
Okay, and did you measure that distance to see if he was accurate?
No,
So how do you know that he's not good with distances?
because the interpretation of my 8 meters were not the same as his 10 meters.
I'm just trying to figure out what you did. So during this interview, he's making some statements about distance that don't make sense based on what you know about the facts of the case, right?
That's correct.
And so you take him outside of the interview to try to come to some determination about how good he is with distances.
That's correct.
If I were to do that, I might look at the distance from here to the bench, and I might say, how much would you estimate that to be? And I would get an estimate, and then I would go measure it to see how close he was. Did you do anything like that?
No, I could not, because we were at the port of entry at our office, and it was busy, so it was just approximate.
What did you do?
I just, like I said, it was from the outside of that little office that we were in to a wall that's within the building that we were.
Okay, so you
making
had
the
him
interview.
estimate some distance.
Yes,
Do you recall what his estimate was?
I don't recall.
Do you recall what your estimate was of that distance?
I don't recall.
Do you recall how far off those two estimates were?
They were not the same.
How far off were they? 1 meter, 2 meters? How far off?
Since I didn't, repeat the question to him, or I just assumed that my interpretation as to what was 5 meters or 10 meters was not the same with it.
Well, so how do you know he's off if you don't know how far off he was?
Because we couldn't he couldn't give me a distance that was accurate, and I didn't try to pursue that issue anymore.
When you're saying he couldn't give you a distance that was accurate, you mean when you take him outside and have him estimate?
Your Honor, asked and answered.
No, he hasn't answered, so overruled.
The distance that we're talking about that he gave you that was not accurate, you're saying it was from a point that he estimated,
Yes.
but you don't know what that estimation was.
No.
How do you know it's not accurate?
Just my interpretation of that distance that we were looking at.
How different was your interpretation from his?
I would say less than a meter,
Okay, so you and he were pretty close.
but not accurate.
Okay. So he's giving you a distance, 15 meters, let's say. He's not going to make an error like 15 meters is really 1.5 miles. He's not that far off, is he?
Yes.
Yes, he is that far off?
15 meters to 1.5 miles is not the same.
Right. My question is, Daniel, even if he's not perfectly accurate with his estimation of distances, he's not that far off based on what you observed in this interview, right?
You would have to ask Daniel.
Do you recall at one point in this interview saying that you need to take a time out? Do you recall saying that in this interview?
I don't remember.
Do you need to refresh your recollection? My
Yes.
page numbers, I wrote the citations down. For some reason, they're off, so let me see if I can find it.
Counsel, let's just jump on the headset for scheduling purposes. All right, we're going to take our 30-minute mid-morning recess. It's 9:45, we'll be back here. Please be in the jury room at 10:15. We'll continue with the examination of this witness. We're in recess for 30 minutes.
Please rise. Move on.
Everyone's here. You can bring in the jury, please.
Please rise.
Please be seated. The records show the presence of all the jurors, counsel, and the defendant. Witness is retaking the witness stand. And as soon as he's ready and you're ready, you can continue with your direct examination.
You still hear me okay?
Yes.
Okay. Just going back to this interview, and I think we got the right pages figured out now. But do you recall at some point in this interview saying, hang on, time out? Do you recall that?
Yes.
And why did you say time out in this interview?
Just to take a break.
Did you, after you said time out, and I'm looking at page 43 there, line 19 and down, you said time out, knowing the logistics, he might be confused. And because he was running away from Border Patrol, his logistics, where he was, because he doesn't know where he's at. You recall making that statement?
Yes.
So you're providing an explanation for something that this witness is telling you, right?
Interpretation.
So why do you provide that interpretation?
Because I believe he was confused.
Why did you believe he was confused?
Because his statement,
His statement didn't make sense. Is that what you're saying?
parts of it.
And so you were trying to provide an explanation for why it's not making sense.
I was just trying to get his information, not interpretation.
Well, and you say that his logistics weren't making sense, right?
Yes.
And they weren't making sense, what he was saying, right?
As to
What wasn't making sense about what he was saying?
just the distance.
Meaning what?
I don't believe they were accurate.
Okay. So they weren't accurate based on your knowledge of the area, is that right?
Based on my experience.
Okay. Did you say at some point that maybe his locations were not defined as you might think? I'm looking at the page that's in front of you, line 5. If you just go ahead and read that to refresh your recollection. And so you're telling him, or are you telling him that, or you're saying that his locations might not be as defined as you might think?
That's not what it says.
I'm looking at line 5 to 7.
Okay, 7 does say that.
Okay, so, and this is a sidebar you're having with the prosecutor in this interview, right? You're not telling this to Daniel.
I believe so.
Okay. And then do you later you explain something to Daniel about what you're telling the prosecutor in this interview? And I'm looking at line 11 through 12. Do you recall that? I'm going to scroll up for you, okay?
Yes.
And you're telling him that he wasn't paying attention when he was fleeing.
I'm asking.
You're asking him if he was paying attention when he was fleeing?
Yes.
Is that what he said? Did he acknowledge that? Did he say, that's right, I wasn't paying attention? Do you recall?
I don't see it on this page.
Okay. I'm just asking if you recall. Do you remember him saying that?
Can you repeat the question, please?
Do you remember him agreeing with you and saying, yes, that's right, I wasn't paying attention because I was fleeing, or something like that?
More or less.
Do you recall at some point telling the prosecutor in this interview that Daniel's thought pattern is not like ours? Do you want me to pull up that page?
Please.
It even highlighted it for some reason. Okay, so just take a look at that and refresh your recollection.
Yes.
Okay, why did you tell the prosecutor that his thought pattern is not like ours? What did you mean by that?
As to our interview and his statement,
Meaning what? Tell me what that means.
he couldn't explain what occurred.
Why do you think he couldn't explain what occurred?
He wasn't in detail with his statement as to what occurred.
When you say in detail, what do you mean?
He was very brief. He was very nervous. It took a while to get him to be comfortable with the interview.
Well, so he did provide some details to you. For example, that 15-meter distance. That was a detail he provided to you, right?
Yes.
So it was detailed, it was just not correct. Is that right?
No.
He says this happened 15 meters away from the border wall, right? That's a detail he provided, right?
Yes.
And that detail, it's just not correct.
It's not correct.
It's not that it's not detailed, it's not correct. Did that ever concern you? So you have this whole interview. You provide him with some explanations. You're saying his thought pattern's not like ours. You take him outside to try to get him to narrow in his distance or to try to judge how good he is with distance. Did it ever concern you that what he said just didn't make sense?
No.
Why didn't that concern you?
Because he was a victim of a crime, and it was probably hard for him to interpret.
How do you know he was a victim of a crime?
Because I was brief on this case, and he was identified as the victim.
By who? How do you know he was a victim of a crime?
Because he was mentioned as a victim of this crime.
Who
before.
mentioned him as the victim?
If I remember correctly, I read the reports.
Somebody can make a false report to law enforcement and claim to be a victim of a crime. That's possible, right?
Yes.
And before you had this interview with Daniel, you were aware of 2 other potential witnesses who had come forward. We've talked about that already, right? Miguel and Ramon, right?
That's correct.
Daniel doesn't ever mention Miguel and Ramon to you, right? Or he says, let me rephrase that. Based on what you hear from him, your understanding is Daniel's the only one present when this shooting takes place, right?
No.
Who else, besides Gabriel? Daniel and Gabriel.
Objection, Your Honor. I'm having a hard time figuring out how this isn't improper impeachment again, and what the purpose of this line of questioning is.
And, Your Honor, the purpose of the line of questioning is to explore how the detective treats a witness statement. He provides explanations, and he provides reasons, and he tells the witness the reasons why the witness is being incorrect, instead of pursuing this witness as a potential suspect or as a potential person who's making a false report. So it's about, thank you.
And, Your Honor, the state's position is that this is just an end run around letting Daniel explain the statement. They didn't confront him with the statement, and this is just an end run around that.
Objection's overruled.
Thank you. So when you interviewed Daniel, was it your understanding from him that he and Gabriel are the only 2 people present when this shooting takes place?
Not that I recall.
You don't remember if he said there were other people there or other witnesses? You don't remember?
He did mention there was other witnesses, but the way you presented the question is that there was never anybody other than them present.
Other than who?
Daniel and the victim.
You're saying that Daniel somehow told you that there were other witnesses present during the shooting besides him and Gabriel?
Based on his statement that when he crossed with a group of people.
I'm talking about when the shooting happens, not when he crosses.
I don't recall if he mentioned anything with other people there at the shooting.
You don't recall, okay. If he were to tell you he's the only witness to this event, but you know that there are 2 other statements out there, does that concern you?
Yes,
Why does that concern you?
because there's other witnesses.
And those statements are not consistent?
I don't know the other statement from the other witnesses.
If the statements are inconsistent, that's a concern,
If
right?
the statements are,
And why is that a concern?
it's something for the court to address.
What about you as a detective? Is it a concern as a detective when multiple people have different statements about an event?
Yes,
Why is it a concern to you as a detective?
because you want to elicit the truth.
And if multiple statements are inconsistent with one another, does that mean one or more of those statements might not be true?
If you repeat the question.
If multiple statements are inconsistent with one another, does that mean that one or more of those statements might not be true?
That's possible.
What do you do to test a person's credibility? Let's say you're concerned. Let's say someone comes forward with statements, and those statements do not make sense according to the facts that you know about the case. What do you do to test that person's credibility?
There's various things that you could do.
What are some of those things?
What is his background? How long did he go to school? If he can properly describe something to me during a interview. There's a lot of factors that come into it.
Okay. So if he can properly describe something to you, what do you mean when you say that?
Exactly what you're asking me to do with you is that if you you ask a question, then I give you an answer to that question.
So let's say, for example, I'm in the interview. I know this happened east of Nogales. I ask this person, where did this happen? He says west. Could you possibly bring out a map and say, can you show me where this happened?
Yes,
That'd be one way to maybe test the person's credibility, right?
that's correct.
Did you do that with this witness?
No, ma'am.
Why not?
I didn't have a map.
Could you go on Google Earth and get one?
Not at the border.
Did you do any follow-up with this problem, this west versus east problem? Did you follow
No,
up with this witness?
I did not.
Why not?
I wasn't tasked to do the follow-up on that, on this interview.
If a witness says, for example, somebody else was there was another person who was a member of the group, and if you know who an alleged other member of the group is, could you do a photo lineup to see if the witness could identify that person?
Yes,
That'd be another way to test this person's credibility, right?
yes,
Did you do that?
no,
Did you try to have the witness do a photo identification of Mr. Kelly at any point?
no.
Why not?
I wasn't tasked to do that.
Do you know if anyone was ever tasked with doing that?
No, ma'am.
These multiple, I guess, these areas of concern. So you're talking to this witness, and what he's saying doesn't make sense. He's talking about distances to the border wall that don't make sense. He's talking about locations that are on the other side of town that don't make sense. When you provided him and the prosecutor in this interview with explanations, why did you do that instead of testing his credibility?
It was based on just the interaction I had with the victim at that point. I didn't think it was needed at that point.
And that's because you just assumed he was a victim?
Based on his statement.
I don't have anything else, Your Honor.
Okay. Thank you. Cross-examination from the state.
Thank you, Your Honor. Detective, if the victim, Daniel, had identified the defendant in court the following day after this interview, would it have been necessary to do a follow-up with a photo lineup?
No, it wouldn't be necessary.
Do you know if that occurred? If you know.
No, I don't know.
But if that occurred, you'd agree that wouldn't be necessary?
Objection
That's
asked and answered.
Sustained.
Defense counsel asked you about some photo lineups. Do you know if photo lineups were done to determine if some other individuals were with him that day? If you know.
I do not know.
You weren't tasked with doing one, but there were lots of other detectives on this case. Is that right?
That's correct.
So if they did a photo lineup, you don't know about it?
No, ma'am.
You talked about the port and not having a map available. Do you recall why that was?
At the DeCasino port of entry, second floor.
I didn't hear what he said.
He said at the deconceiving port of entry, second floor. Right. So we were at the deconceiving port of entry, second floor. Were there issues, were there reasons why we weren't able to connect?
Yes, it's kind of at the border. It's no man's land. Cell phone service is not available.
Kind of sketchy there? Cell phone service is kind of sketchy?
It's almost nil.
Okay. Now I want to go back to your interview with Daniel. Do you recall Daniel describing other things about the location of where this incident occurred and where he was that day?
Yes.
Did Daniel describe for you crossing the border at the end of the border wall?
Yes.
Did he describe for you going to an area he called Washington?
Yes.
Are you familiar with an area called Washington Camp?
Yes.
Where is that in relation to the end of the border wall?
Approximately a mile and a half away.
And which
Parts
direction?
be due north.
So just north of the end of the border wall is the area called Washington Camp.
That's correct.
Did he also talk to you about an area called Keno Springs during your interview?
Yes.
And where is Keno Springs in relation to the end of the border wall?
Approximately 2 miles northwest of the border,
The end of the border wall.
the end of the border.
So, and where is Keno Springs and Washington Camp and the end of the border wall that are close to those in relation to Nogales?
It's east of Nogales.
So when Daniel told you he was at Washington Camp and Keno Springs and the end of the border wall, but that occurred west of Nogales, which thing did you think was correct?
That he was east.
Okay. So when Daniel described Keno Springs, do you recall him describing the area at all?
Yes.
What do you remember him describing?
Descriptions of the row of houses.
Did he describe some pine trees in the area?
In the hills.
If you recall.
Yes.
And would it refresh your recollection if I showed you the transcript?
Yes.
Showing the witness what's been marked as State's Exhibit 18 on page 133. If you could take a look at the bottom of page 133 and the top of page 134. Let me know when you want me to advance it.
Go ahead. Yes.
Does that refresh memory?
Yes.
And can you tell me what Daniel said about the houses with the pine trees?
That it was close where Gabriel died, or it was farther from Gabriel. That was line 9. And then you're on 135 now.
Yes. So what was the eventual answer about where the house with the pine trees were? After you were able to explain to him what your question was.
The house was farther away, as in reference to the pine trees.
Okay. So the house with the pine trees was farther away from where Gabriel died. Is that what the transcript says?
That's correct.
Tell me about what Daniel told you his educational experience was.
That he attended school up to 6th grade.
And what did he tell you he did for a living?
That he worked on farms
As a farmhand?
as a farmhand.
Did you talk to Daniel about the sequence of events and have concerns as you talked to him about his ability to do distances?
Yes.
Did he describe for you running from the Border Patrol in Washington Camp to the Keno Springs area?
Yes.
And did he describe that he ran for about 30 minutes?
Yes.
And I want to go specifically to a page 31. Did you ask him about when he initially crossed the border wall?
Yes.
And when he talked to you about crossing the border wall, did you ask him where he went?
Yes.
And are you familiar with that area?
Yes.
And did he describe crossing the border wall and going up a hill?
That's correct.
And then did he describe that as 10 to 15 meters?
That's correct.
Was that accurate?
No.
And he said he was about halfway up the hillside, is that right?
That's correct.
And did he describe for you that there was a horse between him and the shooter during your interview?
Yes.
And then when you spoke to him, he said that the shooter was 7 meters away. Is that right? Not on this page, but on the previous one counsel showed you.
Yes.
Would that make sense if the horse is between him and the shooter?
Objection,
That it's only
argumentative.
7 meters?
Objection sustained.
Would it be possible for the horse to be between him and the shooter if it was only 7 meters?
It's possible.
It is possible?
It is possible.
Okay. Is that likely?
Yes.
It's likely that he's that close and there's a horse in between?
Objection asked and answered.
Sustained, that's his answer.
And what did Daniel tell you about how he was feeling at the time he got shot at?
He was in fear of his life.
And before he got shot, did he tell you what his health was like at that point because of fleeing from the Border Patrol?
He was tired.
And did he indicate to you that he was sick?
Object, Judge. There needs to be a non-hearsay purpose for this.
Judge, the defense is challenging the witnesses' distances and whether this witness did something improper with suggesting that the witnesses' distances were off, when in reality there are a lot of reasons why this witness's distances were not appropriate, and that's what I'm eliciting. The witness was sick.
It's hearsay. and-
Let's do a brief bench conference here.
Detective, were there numerous times during this interview that it was very clear that Daniel's ability to judge distances was inaccurate?
That's correct.
Do you know anything about the other witnesses' statements that the defense asked you about, Ramon or Miguel?
No.
Were you tasked with assisting and tracking down Miguel on the number that was provided to 911?
Yes.
And what did you discover when you tried to call that number?
If I remember correctly, a person answered and didn't answer after I identified myself.
They hung up.
Yes.
And what about Ramon? Did you assist the Sheriff's Department in attempting to track down an individual named Ramon?
That's correct.
What did you do?
I believe Ramon was living in Nogales, Sonora. We called the number listed, and his mother answered.
When you interviewed Daniel, what was his demeanor like that day?
Very nervous, very almost sick to the point of during the interview that he was not well.
What did you attribute that to?
He said that he was still suffering some mental issues because of the shooting.
Did he talk to you about nightmares?
Yes.
And did he talk to you about other physical ailments he was having as a result?
Yes, yes.
And what were the physical ailments he talked about?
Objection, hearsay.
That's all I had, Your Honor.
Redirect examination.
Thank you. Real quick, the state was asking you some questions about photo lineups and if you knew whether Daniel was ever presented with a photo lineup that included Ramon. And you said you didn't know about that, right?
That's correct.
If Daniel were provided with a photo lineup that included Ramon, and if Daniel was not able to identify Ramon, would that be an additional concern to you?
Again, Your Honor, this calls for speculation and foundation.
Overruled.
So you can answer.
Yes.
That would be an additional concern.
Yes.
The state was asking you about some pine trees, or some of Daniel's statements regarding pine trees. And can you put this up in front of the witness, Lydia? I'm just going to show you this portion of the same transcript involving pine trees. You go ahead, read that, and let me know if I need to scroll.
Which line?
Go ahead and start at line 4 and go until line 17.
And out of fairness, for what purposes this statement of Daniel being offered?
Your Honor, it's again not offered for the truth of the matter asserted. It's clearly not true. The statement is
Okay,
saying.
that's fine. You've said enough. Thank you.
Okay.
All right.
Did you get a chance to read that?
Yes.
So Daniel, when he talks about pine trees, do you recall he's telling you he is near some pine trees that are right up against the little road that goes right along the edge of the wall.
Your Honor, just for the record, this is a different reference, so if we could have the page reference for the record. This is a different time in the transcript and a different reference.
Page 118. Do you see that where he's saying there are pine trees that are right up against the little road that goes right along the edge of the wall? Do you see that?
No, I don't see that.
Line 6, it says, like some pine trees that were right up against the little road that goes right along the edge, and then there's that goes, line 12, that goes along all of the edge of the wall. And I went running along that edge, and then I was looking. I looked, I saw that person.
He, on line 10, he says that he's going through where the wall is, and then he was running out to the edge. And that's when he saw that person. I don't see where he.
All right, let's publish this page to the jury. I think
Sure.
that this is, I'm exercising discretion in this regard because I think it's relevant to the examination. Just this page.
Okay, fair enough. So Daniel is telling you that he sees some pine trees that are against the edge of the road that goes next to the wall. Is that fair to say?
On which line does that say?
All right, just one second. For the jurors, this again is another demonstrative exhibit. This is just to try to aid with your understanding of this examination of this witness on this point in the testimony. This is not evidence itself, but it's just demonstrative, so you can understand what the questions are directed to.
Your Honor, can we go on the headset, please?
Yes. You can go ahead.
Thank you. So you see line 6, where Daniel says, I mentioned before like some pine trees that were right up against the little road that goes right along the edge. And then I'm going to line 12, that goes along all of the edge of the wall. And I went running all along that edge. And then I was looking, and I looked, I saw that person. So he's describing seeing pine trees on the edge of the border wall, correct?
No, it's two different issues there. He's describing the pine trees where he was, and the mural is, if I look at it correctly, on line 10, he's saying that he's going through the edge of the mural.
He's running along.
He's describing, if you don't
Go
mind,
ahead.
he's describing when he's at the wall, when he was at first talking where the pine trees were.
So when he says,
he jumps his statement as to where he was.
so I understand that's your explanation. But what he states is there are some pine trees that are right up against the little road that goes right along the edge of the wall. That's his statement. Right? That's what he says,
Let's have
right?
the certified court interpreter
Yes.
interpret those lines from English and from Spanish into English. All right, so
That would be line 1 through 3 and line 10 through 11.
right. We got to make sure you record it, and where's it? Give her the microphone, please.
Your Honor, interpreting the certification, you would like me to interpret line 1, 2, 3,
10 and 11.
and 11. Okay.
Correct, but we need to make sure you're projecting and you're recorded, so we need to, thank you.
Bueno. It was at the same time in the same area where I went up then when is it that I come out of the wash? I went up, there were some trees. What can I tell you, the last time when it was like pines that were next to the little highway that goes along the edge. that goes along the edge where the wall is, and I went running by the edge, and then I was looking, and then when I looked, I was looking at the person.
Thank you. All right, you can resume the questioning.
So he's describing running away from this shooting, looking back when he's at the end of the wall and seeing the person, right?
Yes.
And you know, based on your familiarity with the area and based on where that property is, that that's not possible, right?
That's correct.
It's not possible to be at the end of the wall and look back and see Mr. Kelly's property, right?
I wasn't there, ma'am. That's what he says.
Okay. Did you have concerns about that when you got this statement?
Not at that time,
Why not?
because we were conducting the interview.
Well, if a witness says something that's obviously impossible based on what you know about the evidence, that causes concern, right?
Yes.
And he's not just, making errors in distance. He's placing himself in a physical spot that he knows, the end of the wall, right? The road that goes along the end of the wall.
Yes.
That's not a mistake that you make because you have a 6th grade education, right? If I say I'm at the end of the wall, but really I'm up on a mountain somewhere, that's a big problem, right?
Yes.
So when you see this statement, you're not concerned that this person might be making a false report?
And that's why the interview continues.
Or maybe this person wasn't there. Is that possible?
I believe he was there.
Even though he's making these impossible statements?
That's why we were having the interview.
Did it ever occur to you that maybe he wasn't there?
Yes.
Why did that occur to you?
For the same reasons that you're giving me.
And what did you do to explore that possibility?
We continue with the interview.
And during this interview, you came to the conclusion that he really was there,
That's correct.
even though he says, I'm at the end of the wall when I look back and I see the shooter. And even though he says, I'm 15 meters away from the border wall when this shooting happens, you still think he was really there?
You couldn't articulate that point of view.
Well, he articulated 15 meters pretty well, right?
Yes, he did.
And he articulated the end of the wall pretty well, right?
Yes, he did.
He even mentioned the pine trees, so he's adding detail, right?
Exactly.
And yet you still think that he was there.
Correct.
Even when he says the shooter was 7 meters away from me, you still think he was there.
I believe so.
You said that he provided there were numerous times in this interview that you were concerned about his ability to determine distance, right? That's what you told the prosecutor, right?
That's correct.
But that's not because when you actually measured distance, he was very far off.
That's correct.
That's just because he's telling you things that you know are wrong based on the scene, correct?
Correct.
I don't have anything else, Your Honor.
And another limiting instruction, I should have given it when you saw this page of the transcript. The statements of Daniel that are being offered by the defense are not being offered for the truth of the matter asserted. They're being offered for the opposite purpose. So therefore, as I've defined hearsay for you before, it's not hearsay because it's not offered for the truth of what Daniel said. It's offered to show that it's the opposite, not true. All right.
And Your Honor, based on counsel's argument, I want to again make the argument with respect to this transcript. And if the court wants to do that on the headset, I'm happy to do that. But based on the continuing questioning,
All right.
I need to make a record.
First, any questions for this witness from the jurors? All right, seeing none, you can still think about it. We'll go on the transcript. Excuse me, we'll go on the headset briefly. All right, we're back on, all right. You all right, Denise? All right. Oh, there's something else? I'm sorry. Hold on one second. All right, we're back on the record before the jury. No questions for this witness, ladies and gentlemen of the jury? All right, I see none. Then sir, you can step down, but hold on a second, because we're going to take a recess. The lawyers and I have some work to do before we take the next step. So it should be about maybe 15 or 20 minutes, don't know exactly, but we'll bring you back in. If it's close to lunch, we'll just recess for lunch. Hopefully, we'll be able to come back and do something else before lunch. But there's a little bit of work we have to do. You know, there's just some things, that the court, the judge, and I have to do with the lawyers, and they have to occur at certain points in the trial. Sometimes they're inconvenient points for purposes of taking a break, but they have to be done. It can't be done ahead of time. It can't be done later. It has to be done right now. So that's why we're doing this right now. So we will stand in recess for about 20 minutes to a half hour, I'm guessing, roughly. And as soon as we're ready to go, we'll have you come back in. We'll stand in recess, thank you. And then the witness afterwards can step down.
Rise before.
Thank you. Please be seated. All right, we're back on the record. The record will show the jury is absent, counsel is present, counsel are present, as well as the defendant. The court has reviewed state's proposed exhibits 143 and 144. 143 is a transcript of a recorded interview with Miguel, who has been identified.
The other one should be 141.
141. Did I?
Okay,
did
you
I
said
make-
144. I just wanted to make sure we were
Oh, all
talking
right.
about the same thing.
Oh, thank you, appreciate that. Law enforcement interview between Miguel and, who were the other participants? Was that from the sheriff's office?
141 was Detective Barba and witness Ramon Felix Gonzalez.
All right, and 141 was, well, it says Aron Felix Gonzalez,
It's Ramon Aron Felix Gonzalez, Your Honor.
and that was also with the sheriff's department. All right, state seeks to use these transcripts, play the recordings of the law enforcement interviews with these two witnesses. Neither of these two witnesses have ever been subject to cross-examination in any manner by the defense. Is that correct?
That's correct.
All right. So state seeks to use these statements for the purposes of redirect or rebuttal evidence. Neither the court's going to sua sponte raise an issue. Neither of the parties has raised it to the objectionability of these two particular interviews. In Crawford versus Washington, 124 Supreme Court, 1334, United States Supreme Court, 2003. The United States Supreme Court looked at a situation, a fact pattern, nearly identical to this situation. The court ruled that it's a violation of defendants' Sixth Amendment right to cross-examination to admit hearsay statements, even if they're under a well-founded hearsay exception under the rules of evidence. It's a violation of a defendant's Sixth Amendment right to introduce hearsay statements that are testimonial in nature, that are offered for the truth of the matter asserted, because it's not subject to cross-examination. It's a Sixth Amendment question. It's constitutional. It's the same fact pattern as this. The witness in that case, in Crawford, from the United States Supreme Court case, gave a statement to law enforcement officers that was incriminating of the defendant, and the prosecution sought to use that and did use that. The court ruled that that statement is testimonial. It's very clear from the case law From the Crawford case and all case law that has discussed it since then, is a statement of this nature to law enforcement is testimonial in nature. It falls squarely within the Crawford decision. The use of this particular statements would violate the defendant's Sixth Amendment right to cross-examine and confrontation of these two witnesses. It hasn't been raised. I'm raising it sua sponte because if the court were to allow this, and if there were a conviction, I have no idea what the jury's going to do. I'm not even speculating on that. But in the event that there were a conviction and the court will allow this, I think it's fundamental error that would result in a reversal and a remand back to this court. So for those reasons, and if the state wants to mark these and have these included as part of the court file but not exhibit, I'm happy to do so.
Yes, Judge, we'd like to do that, and that would be with exhibits 141, 142, 143, and I believe we have the 911 calls marked too, Your Honor. But before I get to that, and I'll give you that.
What's 142?
It's the actual recording that the state intended to play.
Okay, very well.
That we have synced to the transcript. We also have the 911 calls, which we would have requested to play as well. I'll get to that in a minute. But with response to the confrontation clause issue, Your Honor, that was directly addressed in the Prazer-Fong case. And what the court said in that case, first of all, the state's not offering the statement itself for the truth of the matter asserted. We're offering the statement for the purpose of rebutting the defense's argument that the law enforcement officer's investigation was inadequate. That's the reason they indicated they offered them, for two reasons. Because they believed they were false, and because the state's investigation was inadequate. And so that's directly on point with the Escalante-Orozco case and directly on point with the Prazer-Fong case. And what the Prazer-Fong case says is that when the defense offered part of the statement, they waived the confrontation clause issue. And that case is the 2005 case in Arizona, Your Honor. And so for that reason, the state believes that the statements should be admissible. And I'll get the other
Exhibit numbers.
number.
All right, well, I have 141 and 143. I'll give these to the clerk. These are not admitted exhibits, just to be clear, and they're to be made part of the court file.
And I have
For whatever
142.
purpose.
I have 142 here also, Your Honor.
Very well. But
Are we making that part of the record as well, just for the record?
that's the recording itself.
Yes.
142 can be made part of the record, but not
Thank
admitted.
you. And I'll find the recording for the 911 and let the court know what that is so we can make that part of the record as
Which
well.
911 call is that?
They're all the dispatch calls with the individual known as, who identified himself as Miguel.
Oh, right, all right. But I mean, obviously, clearly that if either of these witnesses were here and subject to being called and subject to being cross-examined live in court, it would be a different thing because they'd be subject to cross-examination. Obviously, they're not here. I'm sure they're not here. One of them, or both of them are
Right, but the
parts
problem,
unknown, so.
Right, but the problem is the defense offered the pieces of their statements that they wanted to offer. The state was never able to rebut that and then claimed the investigation was inadequate, and the state didn't get an adequate opportunity to rebut that. That's the state's argument. That's why we're arguing we're prejudiced in this case.
Free to argue it, make your record, appreciate that. But I feel that this is a very clear, to admit these particular recordings and statements by these witnesses who are not here, not subject to cross-examination, and therefore we're not able to fulfill and accord satisfaction to the defendant's Sixth Amendment right to cross-examine and question these witnesses. And I've read these statements, and they contain a lot of information that is highly prejudicial. And for whatever purpose, if they're not offered for the truth of the matter asserted, I think it's even a larger violation of the defendant's Sixth Amendment right to permit that to be done. But you made your record, court's ruled, I'm not going to permit those two recordings to be played, given the Crawford case and the Sixth Amendment analysis that the court's applied to the case.
Your Honor, and the other exhibit number is Exhibit 144, if that could be made part of the record as well.
So granted, so ordered. Okay. Mr. Jetty, you spoke before, so where does that leave us?
The state rests, Your Honor. No rebuttal witnesses, Your Honor.
Very well. So what we're going to do is I'm going to bring in the jurors, the state can rest, and then I'm going to tell the jurors we're going to need, I would estimate, about an hour to finalize final jury instructions, get them copied and printed out. We'll come back, I'll give final jury instructions. That'll probably take, I don't know, well, what do you think, Denise, about 45 minutes? 45 minutes at the most, and then we will probably recess for the afternoon, come back tomorrow for closing arguments. Counsel, the court's going to limit time and closing argument to 90 minutes per each side. That should be plenty of time. And the state will have 90 minutes as well. The state can watch the clock and reserve whatever time from the 90 minutes for you think might be necessary for rebuttal. Fair enough?
Your Honor, I think since we have the burden, I'd ask that we have additional time for rebuttal. That would be our request.
All right, I'll take that into consideration.
Thank you.
You're welcome. All right, let's, anyway, that's the plan. Let's bring in the jurors, please.
And Your Honor, I think the further record on that is that this has been a 4-week trial. I don't think that 90 minutes is adequate to cover.
Well, I think this jury has had the facts presented to them. The jury has had the facts presented to them, and they understand what the facts are. I think it's more about arguing the facts and how they apply to the law. I mean, all of the salient facts have been produced and repetitively, so let's just leave it at that. Not to mention the fact that the parties had opening statements that were somewhere between an hour and a half and 2 hours each, which basically laid out the entire case in the beginning.
Please rise.
Please be seated. The record will show the presence of all the jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. Let me tell you where we are, what's going on, and what's going to happen next. Well, first, I'm sorry. Does the state wish to present any evidence in rebuttal?
No, Your Honor, the state rests.
Okay. State's rested. What does that mean? All the evidence is now in. State's presented its case in chief. The defense has presented its case. The state is not going to present any rebuttal case in chief. All the evidence is in. So what I need to do now is meet with the lawyers. We didn't do it over the lunch hour. We took a break. I need to meet with the lawyers. We need to finalize the final jury instructions. We've already been working on it. They have drafts, and they've reviewed them. We've been working on them. Once again, so I'm going to have to send you out, but I'm explaining why. Because this is, again, something I can't do with the lawyers until everyone's rested and all the facts are in. Couldn't do it before. We kind of started the process, with drafts of the jury instructions, but now we've got to review it to make final instructions. We'll have Jose here in the courtroom. We'll make those changes. He's been warming up his fingers. So that gets done efficiently. And once that's done, we'll copy them off. You'll come back in, and I'll redo the final instructions just the way I did the preliminary instructions. Then given the hour, what we'll probably do is recess for the day. We'll come back tomorrow at 8:30, and when we begin at 8:30, we'll begin closing arguments by the parties. And following the closing arguments, I'll give you some very brief final jury instructions about what to do when you go back there. And at that time, we'll pick the 4 alternates, assuming we still have all 12 jurors, and then you'll begin your deliberations. So the case will be submitted to you, likely for deliberations tomorrow afternoon. So I need to meet with the lawyers, so what I need to do, I'm sorry, we got a little bit of a gap here in time where you're going to be waiting in the jury room. It should take about an hour. Again, couldn't get it done before this moment, so apologies there, but we'll be in here working. I'm going to excuse you. Any questions about any of that, folks? Yes, ma'am. What'll happen? I just allergies. Sorry. What happens to the alternates is, yes, they do not participate in the deliberations, and I'll explain. But since you asked, that's okay. The alternates will leave. They will not participate in the deliberations. The alternates, however, will not be reduced from the court's admonition to not talk about the case unless and until a verdict has come in. The reason for that is that in case there are going to be 8 persons who are going to end up deliberating, in case any of those 8 persons who are actually deliberating cannot complete the deliberation process. Maybe somebody gets sick or they have a family emergency, and there's a deliberation and they can't complete it. What will happen then is we'll draw a name from one of those 4 alternates, and that alternate will come in and substitute in and be part of the jury deliberation process. Once a verdict has been rendered, we'll call whoever the alternates are and tell them, case is over, we'll tell them what the verdict is, and that they're released from the admonition. So you're not really, if you're an alternate, you're not really released from the jury service until we call you and tell you that there's a verdict that's come in for that reason. And that does happen. Sometimes people, for whatever reason, can't complete the deliberation, and we got to substitute somebody in. So that's what will happen. All right? So I'm going to excuse you. Please wait in the jury room, hopefully about an hour, and then we'll come back and we'll do final jury instructions. Any other questions? Good. All right, you're excused until further notice, and I'll stay here with counsel and we'll work on the jury instructions.
Please rise, por favor.
Excuse me. I need the most recent final. Yeah.
Should we start passing that out?
Yeah, just get somebody else to do it. All right, have a seat, I'm sorry. All right, to the public and the media, we have a legal discussion here about the proposed jury instructions. We do it off the record, and then we go on the record to preserve final objections that the parties may have. You're welcome to stay. You're welcome to go as well. This is usually not one of the more interesting parts about the process, but if you're interested, thank you, you're welcome to stay. And as I said, I told the jury it should take about 45 minutes or an hour to get this done. So we will, we go off the record for purposes of the court reporter for now, and you're welcome to keep the camera running, you're welcome to stay, but fair warning if you do, okay? Okay, we got Jose, we have counsel, and we have the proposed instructions.
Your Honor, may I ask a question?
Yes, ma'am.
Can we all participate or
Yes.
only one speaker?
You can all participate.
Thank you,
It's
sir.
very informal.
Thank you.
Thank you for asking. Okay, you know, the first several pages are all standard instructions.
Can I
know there was
have a
mis-
concern about the first page?
Okay.
And I know that I'm coming from a different jurisdiction, but I do have a issue with the fact that the jury is required to determine what actually happened. If we were to give them that instruction, then because of the uncertainty of a lot of facts in this case, they will be deliberating a long time trying to figure out who did what and trying to solve the case, which I don't think anyone can, in my personal opinion. And I feel like it's not the right burden.
I agree with you, actually. No one's ever brought that up before.
Thank you. She looked at me really weird. I'm just kidding.
No, yeah, it's usually, but no, their job isn't to determine what happened. Their job is to determine what the facts are, so. So
Thank
it
you,
said,
sir.
we can change that to you as jurors are the sole judges of the facts.
Yes, sir.
Okay. Are you with us, Jose?
I don't know where we are, Your Honor.
First page.
Page 1. Duty of jury.
Is this not the Raji?
It is, but she makes a good point. So Raji are recommended, and I think she makes a good point.
I would object. I'd ask that we use the Raji that we've used for decades.
Understood. Raji are, I think they're recommended. I think that's what the R stands for, so, or maybe it's revised, I don't know. Anyway, are you with us there?
Yes, I just logged.
So it's the end of the second paragraph. You as jurors are the sole judges of the facts.
And actually, the first sentence of that second paragraph also says you have to determine what actually happened.
Okay.
Same objection, Your Honor.
Noted. So look at the second paragraph, the first sentence. It is your duty to determine what the facts are in the case by determining the facts instead of, and take out what actually happened. And then the same thing at the last sentence of that paragraph.
I don't even think that first sentence makes sense, Your Honor.
I think if we just cut it off, I think if that
Yeah.
first
What
sentence
the
of the
facts are.
second paragraph,
Okay.
it is your duty to determine what the facts are in the case, period.
Good, okay. So that sentence, that sentence is your duty to determine what the facts are in the case, period. Okay, you got that? Good, all right. Anything else, let's say through pages 5?
And I was wondering in that, just on that same page, it just might be a little bit better, but not mandatory, but the last paragraph, the second sentence, as you determine, I just wanted to know if the court would consider review the facts.
We're on.
Pardon?
I think it's fine the way it is.
Okay, that's fine, I'm
It
okay.
doesn't change the content the way
Yes,
your
sir.
other,
I have no
the
problem.
meaning the way your other suggestions,
Thank you for listening.
of course. So, let's see, through page 6, 7, or any, stop me if you, I know we had an extra, we had 2 different instructions here depending upon whether the defendant was going to testify or not testify.
Judge, and I think burden of proof,
I don't-
I'm not sure if counsel's asking for the second half of that.
Tell
On
me,
page
tell me what
10
page you're on.
I don't know
4.
if we, did we, oh, we're on page 4. I got too far ahead.
What's the question about page 4?
I think this is 2 instructions in one. Is counsel asking for both? I don't care. I just want to make sure the record's clear.
Yeah.
Yeah,
So we, all
I'm asking for the whole thing.
right, there's 2 different instructions on burden of proof, but we'll give them both.
It's fine.
All right. Stipulations, redactions.
I don't recall if we had any stipulations, so I don't know if we need
We didn't, Your Honor.
the stipulation.
That's page 10.
Yes.
So Jose, we can just take all of page 10 out, that whole instruction, stipulation. Agreed?
Yes. I also don't know if we have redacted exhibits.
We do. The text messages.
Oh, okay.
All right, so we'll leave page 11 in.
And then I think just defendant's testimony needs to come out.
All right, so defense, I assume you want us to leave, well, I don't want to make any assumptions. Page 16, defendant need not testify. Do you want
Leave
that?
that in, yes.
Leave that in, okay, sometimes people don't. And then we'll take out, so Jose, we're going to page 17, that'll come out. Defendants, you must evaluate the defendant's testimony the same as any witnesses, right? That comes out, he didn't testify, right?
Correct.
Okay.
And the next one.
18 stays in, correct?
Oh, yeah, that's right. It's his statements. It came through other
Yes.
people. Yes.
Correct? Witness's prior conviction, cooperating witness had a prior conviction, correct?
Yes.
So we'll assume the state wants that in there.
Yes, Your Honor, the victim did.
That's page 19, so that stays in. All right, now, is there anything before that? I'm looking at page 20. There's
We
some
don't have page numbers.
We don't
What's the
have page
heading?
numbers.
What's the heading?
evidence for a limited
Yeah.
purpose.
I think we wanted one out and the other one in, right?
Right, I think this would both deal with the text messages, so I would prefer the next instruction on other acts.
Your Honor, I think we need evidence for a limited purpose for multiple reasons. Detective Barba's testimony regarding all of the other witnesses, the court allowed that only for the limited purpose of determining whether their investigation was appropriate. In addition, there were 9 photographs that were photo lineup that were admitted only for the purpose of determining whether law enforcement did an appropriate investigation. In addition, Your Honor, there was the impeachment of Detective Raul Rodriguez that, again, was only offered for the limited purpose of determining whether the investigation was appropriate. They were not offered for the truth of the matter asserted. Those are very important instructions for the state.
Right, I think there was a number of times I gave limiting instructions on hearsay and otherwise, so.
So what
Yeah,
do you
that-
fill in?
So here's what, let me tell you the language I propose to use, okay? So I think we do need the instruction. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose stated, only for the limited purpose that the court stated at that time.
Judge, and I don't think you gave that limiting instruction with Detective Rodriguez, and I would ask that we are specific with the jury. I think the jury needs an instruction in the back reminding them of the limiting instructions. I would ask for that with respect to all
So
of
this
those
is-
issues.
Well, I mean, I gave limiting instructions, we just reviewed some of them, you did as well, in a number of different contexts and different types of limiting instructions, hearsay and the other things. You know, I don't want to confuse the jury or give them excessive information by going through each and every example or situation where the court gave a limiting instruction. You can argue that to the jury if a limiting instruction was or was not given with respect to certain evidence.
And Your Honor,
But I'm not, what are you asking me to do, to give an instruction that I did not give a limiting instruction when, for Detective Rodriguez? or-
I'm asking you to clarify for the jury what the purposes of the limiting instructions were, specifically with Detective Barba and Detective Rodriguez. I think they need that in writing specifically, and I believe it's very important for the state's case that we make it clear that that testimony was only for the purpose of determining whether the investigation was appropriate. And I don't think the court gave the limiting instruction during Detective Rodriguez's testimony. And so I believe that's extremely important with respect to Detective Rodriguez's testimony.
If I didn't give it, no one asked for it. I'm not going to do that. You can state your objection on the record. I think that's more information, more detail than is appropriate for a jury instruction in a case such as this, 4-week trial, numerous different types of limiting instructions. You're welcome to argue to the jury that the court gave you a limiting instruction or didn't give you a limiting instruction as to particular testimony, and when you argue the case, place it in that context with the jury. But, I mean, I guess I haven't heard from the defense. Do you have any objection to the language as proposed?
No, that was good, Judge.
Right. And again, you'll be able to, when we go on the record, both parties will be able to make formal instructions. All right, so Jose, I'll give this to you when we break, okay? And you still want the other act, oh yeah, we kind of run out of page numbers. You still want the next instruction, which is other acts, correct?
I think that only applies to the text messages, but give us 1 sec, Judge.
Sure.
Could you reread one more time what you're proposing on the other one? Of
course.
Limiting instruction.
Evidence for a limited purpose. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at the time.
Judge, I don't think we need this one since you already provided that one. I was just thinking of the text messages, but I think during trial you provided a limiting instruction regarding those as well.
You're talking about the other acts instruction?
Yes, so I think we could take that out.
State's position?
On the other acts evidence?
On the other acts instruction.
No, I think it needs to come in as well. I think they both need to come in.
All right, I think the other act, I'll give the other acts instruction. If you want to make an objection to that, then you can when we go back on the record. All right, separate counts. Then there's a couple of final instructions, the jury foreperson in closing.
Judge, there's
But-
one before that the state's requesting, and that's standard instruction 44, which is the motive instruction. I didn't see that the court included that, and I would like the motive instruction added. I can email it to your JAA if you'd like.
What's the defense position?
We're okay with that, Judge.
All right, if it's fine, then there's no objection by either side, I'll give it. If you'll email that to Jose, it's a
Yeah,
very short.
Once we read it, of course. We'd like to read it, too.
Sure, it's really short.
I'll
Well,
include
email
the
it.
defense, of course, as I'm ethically required to.
Okay. So what I was then saying is we go into, these need to be just reorganized. There's some closing instructions, and we'll take those out, and those will go, I'll read those, thing about the jury foreperson and the closing instruction. I'll read that after your closing arguments. So then we're going to go to the statutory definition of the elements. So I'm looking at the first one that says second-degree murder.
It's this packet, right? Judge, the only thing we had on that were some punctuation issues. And it looks like the new second-degree murder, I think it's now has some brackets. I'm looking at page 33. Is that what the court's looking at?
No, I'm just looking at the one that says second-degree murder, the crime of second-degree murder requires proof of any of the following. It just says the elements. There's no
Your Honor, I would have had knowingly under number 2 instead of new, but that may be just your state. I don't know. But everything is intentionally, knowingly, or they're all recklessly, and that one just says no. I just thought knowingly would fit better.
And Judge, I think this tracks the statute.
Yeah, I think so, too.
Okay, and that's something I'm not aware of.
That's fine.
And
All
Your
right.
Honor, we got a new set from the JAA for the end of your jury instructions. So I think they've been redone already, and he included some bracketed
I know.
language as well.
We're going to get to that.
Okay, but
But
it's
the
the
one
same
that I have,
instruction.
the second-degree murder, is just the Raji, just from the,
Right, but
it's got 1 or 2 or 3.
It's the same instruction, it's just later in your packet. It's the exact same instruction, it just has additional bracketed language.
Oh, yeah. Let me see. All right, what do I,
It's on page 33 of what Jose gave us.
yeah, but I understand. It looks like I'm looking at something different.
Because I just want to make sure we were all on the same page.
Jose, I don't think I don't have that in this thing you just gave me.
Why are we jumping here? Which one? 33 is over here. We haven't gotten there yet. Get a clean copy. This is just. And you can look at this while.
Oh, good. Okay. Good, thank you. All right. Let's see what's going on here.
And I sent that instruction to Jose, so he should be getting it in a minute.
Motive instruction.
Yeah, the motive one.
All right, I see what you're talking about. I don't know what the difference is. But... Oh, it just substitutes the initials of the deceased, right, for another person.
Yes, Judge, and there were some typos and some
What about-
formatting issues as well.
What about
with
the
first
one, what about the first one that has GCB?
I think we could put Gabriel's name in there, Gabriel Quinn Butimea. I don't think it needs to say of another person, so I think putting the victim's name in is appropriate. And then there are just
Defendant
some,
caused the crime of second-degree murder requires proof of one of the following. The defendant intentionally caused the death of GCB, or the defendant caused the death of GCB by conduct which the defendant knew would cause death or serious physical injury, or under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. I mean, that's
Yes.
that's the instruction.
yes, I don't have any objection to the instruction, Your Honor, just some formatting issues. I just wanted to bring to the court's attention that we had this twice
Okay,
in the
good.
packet you sent.
All right, so that one's okay.
Just that I would ask that we move the "or" up to the first line, and that we would put a semicolon in the second line, at the end of the second line, the number 2.
All right. I'll go over that with Jose. We'll go over that later.
And then there should be a period at the end of number 3.
Good. Okay.
That was all I had on that one.
All right, what about the next page, aggravated assault?
Your Honor, I feel like we left out the name of the victim in this, and I propose that we put it at the end of number 2. The assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument against, and then the victim's name. Nowhere in there are we identifying the victim, so the jurors will be confused which one's the victim in this one.
Okay.
I don't have an objection. I would add it to number 1, Your Honor. The defendant committed an assault on Daniel Ramirez.
But it's "and."
On Daniel Ramirez, and the assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument. And then also, under the assault definition, I would...
Hold on, let's get to, how about that defense? The defendant committed an assault on Daniel Ramirez, comma, and, does that work?
And the assault...
I'm just kind of, off the top of my head, I'm just thinking, it seems there needs to be something to explain to the jury that he would have to use the deadly weapon or dangerous instrument against that particular person in order for that to be.
How about the defendant used a deadly weapon or dangerous instrument during the assault?
I don't have an objection to that, Your Honor. I don't think it tracks the statute. I think it's unnecessary, but I think adding on Daniel Ramirez is fine. And I also
Adding Daniel Ramirez, I mean, I take your point that it's, so they're not confused about who the victim was on that particular charge. But,
Right.
Can we
All
put
right.
the name in both?
all right,
And,
so
Your
I'm
Honor,
gonna-
I think we could add it again down in the assault. I would ask that we not add it to the deadly weapon portion, but intentionally put, instead of another person, we could say Daniel Ramirez.
So what I'll say is then, under it says assault, the crime of assault requires proof that the defendant intentionally put another person, and then I'm going to put in parentheses, Daniel Ramirez, in reasonable apprehension of imminent physical injury. Okay?
Yes.
Then we have definitions: knowingly, intentionally, intent, recklessly, reckless disregard. Those are all,
And just to, I'm sorry to go back, but I don't think we ever cleared up whether we were going to use Gabriel's full name in the second-degree murder. The state is requesting that we use his full name, Gabriel Quinn Butimea, instead of the initials.
I leave that to the court.
okay, full name. All right, and we'll go over these. Jose, we're going to go over these.
And if, just to be consistent, if we're going to use full names, when we go back to the aggravated assault, we'd ask for Daniel Ramirez Ruiz, AKA Daniel.
Now, see, this is what starts to happen, okay?
Well,
And we're trying to get this done so we don't keep these people waiting here all afternoon for changes in semicolons and stuff like that. If there's something really substantive, let's raise it. Otherwise, I really don't want to hear it. You know, if it's something that substantively changes, the actual instruction clarifies it in some way, but, you know, we're not going to, a lot of this is, I just put Daniel Ramirez, and we'll do that. It's just to make sure there's no confusion between the two victims. All right, and if you want to make an objection on that, you can do it. All right, so then we go into the definitions. Those are all standard. Anything
Senator, we're missing physical force, the physical force definition. We have deadly physical force, but we don't have physical force.
All right, do you have that? You send it to,
I do, Judge.
send that to Jose, send it to defense counsel. It is in there? Where
I
is
see
that?
physical injury, but I don't see physical force.
Oh, yeah, it is up there.
Where is it?
It's on the top of the next page. Yeah.
Where?
After rec,
That's not a definition. That's actually the instruction on justification.
well, it's in the one I have.
Oh,
Definition of deadly physical force. Deadly physical force means either force which is used for the purpose of causing death or,
right, it's not the deadly physical force we're missing. It's physical force
Oh,
we're
physical.
missing.
oh, I got you.
So would you like me to email that one?
Yes, okay, so we need physical force came to email. All right, now then, anything else about the definitions until we get to causation, ignorance of fact? So the next
I don't think
the
dangerous
next
offense-
series, what's that?
I don't think dangerous offense should be here, Judge. That's for the aggravation phase.
Yeah, I agree.
Oh, okay,
So that one needs to come out.
thank you. All right, out. Good. So the next series of instructions are all defense-requested instructions concerning justification.
I've sent the physical force instruction, Your Honor.
Thank you. These are all defense instructions. There's one line to be filled in. I'm not sure what that is.
Is the causation, ignorance of fact, is that a Raji? I'm not familiar with that one.
I don't think we need it. Yeah, I don't know that we need the causation or ignorance of fact. I'm not sure why that's in there.
These are, if you don't want it, well, these were ones that you
Yeah,
suggest-
we can take that one out.
All right, causation, ignorance of fact, we'll take that out.
And Your Honor, I think the only, so for the justification use of physical force, I don't think that one applies because I don't think there was physical force used in this case. If you look at the definition of physical force, what it says, this is the instruction I just sent to everyone. It means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. I don't think there's any facts in this case that Mr. Kelly physically assaulted anyone, so I don't think that definition comes in. It's duplicative of the deadly physical force one, and that one is the one that I think is applicable.
And Judge, I would just say that if Mr. Kelly is firing up into the air to try to scare people off of his property, then he is using physical force. He's not using deadly physical force. He's threatening deadly physical force, arguably, and also using physical force.
That's not physical
Well,
force.
Let me say, I've read a lot of case law on jury instructions for justification and self-defense, and they consistently say that if there's, I think the word they use is a scintilla of evidence to support the defense, the court's got to give the instructions. So I'm going to give that instruction.
I just haven't heard what the scintilla is, Judge. That's the only thing I'm looking for, is we have a defendant who shot his gun in the air. It's either threatened use of deadly force or deadly force, depending on whether you believe he shot it in the air or whether he shot it at them.
Got it. You can make your objection, formal objection when you
Okay.
get to it. What about the rest of these? These are defense requested instructions. Do you want these instructions?
Judge, and I would argue that
Can I hear from the defense, please, first?
Oh, sure.
Yes, Judge, we want justification for self-defense, justification for self-defense involving physical force, and justification for defense of a third person, justification in defense of premises.
And that one, I'm just going to stop you. I don't know what, there's a blank there. I'm not sure what that was. Do you know what that was? Justification in defense of premises. It's, I don't have page numbers anymore, but it's in the middle of it's the bottom half of one of the pages. And the first line, there's just a blank.
What?
It was some brackets that I needed to add, so I left it blank, because I didn't know what certain brackets said, but I did add them in their copy.
Oh, you have those? All right. What does it say? What's in the brackets?
It says, in threatening to use deadly force, deadly physical force, in using physical force, in attempting to use physical force, in threatening to use physical force.
Judge, can I approach? I can just give you my copy.
Yeah, that would be helpful. I appreciate that. I mean, I don't know why it's difficult to work off the same, different pages. Thanks. Thank you. All right, I got you.
And Judge, I would like to talk about the third person one as well before I know you're looking at this one right now, but I would like to
The third person
discuss that one.
is his wife.
Yeah, Judge, but she's inside the house. There's no indication that anyone ever threatened her, so there's no defense of a third person here.
Well-
She's inside the house. No one ever pointed a gun at her. No one ever pointed a gun at anyone.
Well, the case law, as I said any scintilla of evidence, I don't know what a scintilla is, but it's probably one half step above microscopic. I'm not going to commit error by not giving instruction if there's any evidence to support the instruction. That's what the case law says, and that's what I'm going to follow. Now, what about on this justification of defense of premises? There's some bracketed in there. We've got to select one
There's
or
a lot
more.
of bracket even above that one, Judge. I'm on 31.
Oh, right, you're right.
That needs to be fixed.
And Judge, as to this one, this is completely inappropriate. There's currently legislation pending because the legislature recognized that this justification defense does not apply in this case. The reason is because it requires that the offense occur on the premises, which is defined as the residence.
Your Honor,
wait.
that legislation that she's referring is just purely castle doctrine on shifting the burden of proof. It has nothing to do with giving the ability to shoot someone out in the property like a lot of the media is saying.
Well, wait.
It's a castle doctrine.
What is there, legislation pending?
Yeah, Judge, and obviously counsel hasn't looked at the legislation because the
I-
legislation
It's not law.
specifically
It's not
changes.
law.
Right, Judge, but what I'm saying is the reason why the legislature is changing it is because they recognize that this justification does not apply in this specific case.
Well, they haven't changed it yet, and the governor hasn't signed it yet.
I'm not saying that, Your Honor. I'm saying this one doesn't apply here because it's the definition of premises in the statute, which has been left out of the version that defense counsel provided. The definition of premises includes that it has to also include a house. So they have to be trying to get into a house in order for this justification defense to apply.
And, Your Honor, to remind you that the threat came to them while they were in their home.
Well, to me, that's a scintilla.
Premises, I had,
Yeah, and Your
All
Honor,
right, all right. We're bouncing around too much. Part of it is my fault because of working off a different draft. Let's look above that on page 31. Ms. Lothar points out, says physical force, there's some brackets there. The brackets mean there's alternative language that can be used in the instruction. What is let's go through this more systematically. What is the defense position on which of those elements should be used that is bracketed?
I'm sorry, where are we?
Right here.
Page 31,
Okay.
physical force was necessary to protect another's use, attempted use, apparent attempted use, or threatened use of physical force against a third person.
I think we might need more than one of those, so could we do or? So physical force was necessary to protect against another's, I would say certainly attempted use, or apparent attempted use, or threatened use. Well, actually, I think we need use too. I think we need all of those, we just put an or of unlawful physical force against a third person.
Your Honor, obviously, we're going to continue to argue that there was no use of force, there was no attempted use of force, there was no apparent attempted use of force, there was no threatened use of physical force in this case, specifically with respect to physical force, under any scintilla of any facts.
We have evidence that was reported by law enforcement officers that Mr. Kelly said he was shot at. Now, you don't agree with that, whether it's proof or not, but, I mean, if there's evidence in the record that that the jury heard that the defendant says he was shot at.
And then 6 minutes later, he said, I don't know, wasn't shot at. It was from another direction. I don't know what direction it came from. And then when he talked to Detective Ainsa, he said, no, I don't know where the shot came from. And he's inside his house. So that he's not shot at, he's inside his house. On all of the fact scenarios, he says he's inside his house.
Can he be shot inside his house? I mean, Ms. Hunley, I understand what you're saying, but I'm dealing with case law from Supreme Court of the State of Arizona, Court of Appeals of the State of Arizona that says if there's any, I mean, the case law is clear. The trial court must give these instructions if there's any scintilla of evidence to support it. You know, it's reversible error. I mean, and there's one interpretation of the facts that you're giving, but there's another interpretation of the facts that facts in the record that show or provide at least a scintilla of evidence that the defendant was being shot at. Whether the jury believes it or not, it'll be up to them. So, you know, I'm not going to get led into error I've done the research. I'm not going to get led into error because you have a separate interpretation of the facts. All right, let's move on. I'm going to put or use or attempted use or apparent attempted use or threatened use. We're going to remove all those brackets. All right, what about number 2, Ms. Larkin? Let me hear from you first.
Same thing, Judge, we'd ask for the ors.
Remove bracket. All right, now the next brackets is where we were before on justification. Let me hear from the defense. A defendant in lawful possession or control of the premises is justified in, and then there are 1, 2, 3, 4 alternatives there.
I think the same thing's appropriate, the ors, and keep all of them. And then there's a bracket at the bottom. It says the force used may not be greater than reasonably necessary to prevent the attempted criminal trespass. So I'd say the attempted or actual criminal trespass.
Okay.
And then on the next page, let's see. It's just reason why the criminal trespass was being, and I would say committed or attempted.
And Your Honor, I don't think there's, I mean, maybe counsel can explain to me how I'm missing it. but
Tell me, first of
there
all,
was no
hold on a second, just
trespass
let me
in the
tell
home.
me, show me where you're looking. What are you talking about?
I'm at the top of page 32, and there's the very first line, there are those brackets where it says committed, attempted.
Mr. Jetty, can I have your instructions again? Because I'm on my 32 is different. Sorry about that.
Do we just want to make a copy of the whole set, Judge?
Let me have the
for
rest
you?
of those. You can just look over Ms. Huntley's shoulder. Thing. I'm sorry about that. Okay. All right, I'm with you now.
Committed, we just want to say committed or attempted. And then the other bracket where it says the defense ends when the attempted, I would say the attempted or actual criminal trespass ends.
Okay. Then the other instructions that follow were instructions that were included in, I don't remember if it was the state's or the defense, but in anticipation of the possibility that there was a lesser included offense instruction added, I assume.
Sorry, we'd ask to take those out.
Negligent homicide,
Homicide.
manslaughter.
We want them, Your Honor.
Manslaughter.
Are you requesting lesser includeds?
Yes, we are.
All right, what's the offense? Because the state can request lesser included.
We're not requesting lesser includeds.
All right, well, then we need another instruction. We need the general lesser included instruction. Well,
I think you already have it in here, Your Honor. If you look down to page 33, is that what you're talking about?
Mr. Jetty, last one he gave me was 32.
Oh, I've got it.
Sorry. Sorry about that. There it is.
Are you on page 33, Judge?
I'm there, yeah.
I think we would just need to take out that second-degree murder because it is a duplicate, but that is the lesser included from the Raji.
I think they should all go in order, Your Honor, starting with second-degree murder, then the lesser, then the manslaughter description, then the lesser of the negligent homicide.
All right, so we'll take out that redundant second-degree murder, right? And then we'll start with the crime of second-degree murder includes the lesser offense of manslaughter and negligent homicide. Manslaughter, negligent homicide. All right. Then on to 34. What about the criminal trespass? We don't.
Your Honor, and I think that what we'd need to do, these are just the lesser included portions. It doesn't, oh, no, they're in there. Never mind. No, I think we actually need to insert the manslaughter description right there where it says manslaughter on page 33. And then we would need to insert the negligent homicide instruction right under negligent homicide. Oh, that one's actually there, but the manslaughter one looks like it's missing here, unless I'm just missing it. And I think the only manslaughter that applies is the reckless, so I don't think we need to say it can be committed in two ways.
All right, I'll reorganize these. What about the criminal trespass in the first degree? I don't know where they.
And that's what we're requesting, and I think the definitions that go with it, we would just ask that we move those to be under the instruction on the
What's the trespass one?
It's part of the justification of defensive premises.
Oh, okay.
And so that just defines those terms, and we would ask that those terms, the criminal trespass and the definitions, be moved so that it makes sense for the jury.
So move to follow the justification.
Yes.
All right. Gotcha. Okay. We got some work to do.
Your Honor, would you like to hear my argument about the justification defense and the premises issue?
Go ahead.
There is a case on point, State versus Level, 97 Arizona 269, that talks about how the the trespassing has to be in the premises. The definition in 13407 says that premises means any real property and structure adapted for both human residence and lodging, whether occupied or not. So this justification defense only applies when someone is getting into the home. There are no facts in this case that anyone's getting into the home. That's why this does not apply.
Where does that definition come from again?
13407 subsection C. And when we give the definition of criminal trespass in the first degree, it's misleading because the definition, the justification definition is limited to premises. And the criminal trespass in the first degree also has the fenced residential yard. And so that's misleading because the justification defense doesn't apply unless somebody's physically trying to get into the home. And so for that reason, Your Honor, I think that these instructions are completely misleading for the jury.
And Judge, the justification defense also applies to attempt. And if somebody's outside of your house with guns and shooting, it's certainly an attempt.
All right, we're going to take a recess. I'm going to get to work on these. We've got a lot of work to do. And then we got to look at them and get them copied off. Hopefully, we'll still be able to get to them this afternoon, but there were a lot more changes than I anticipated, but that happens. That's all right. All right, anything else of a material nature that comes to mind?
No, Your Honor.
All right.
Judge, I'm just not sure if I indicated that and perhaps I did, and I apologize if I'm being duplicative, but we do oppose the third-party one as well. If I've made that argument already, I'm sorry.
That's all right, and you'll have another opportunity to make a formal record when we get to the final draft before you.
I just wanted you to know that before you got to work.
Got it. Thanks. We're going to get to work. I don't know how long this will take, but we'll be working.
Rise, por favor.